Okay, good afternoon. We are delighted to welcome you to the last of our three-part webinar series, which provides an overview of key changes in contractual interpretation, contractual notification and freedom of contract. And today we're examining the doctrine of freedom of contract and the government's and courts' ability to intervene with this freedom through legislative and judicial restrictions. This webinar series has taken us back to the basics of contract law. The law rarely stands still, and it's always important to keep up to date with the very latest judicial developments. All of the webinars from our series have been recorded and are available on our Vimeo site if you couldn't join us live or would like to listen again or share with colleagues. Just before we begin, to minimise background noise, I've placed you all on mute. If you would like to ask questions, please do so using the webinar chat function, and time permitting, we will answer some of these at the end. I'm Iain Drummond, a partner in the Construction and Special Projects team, specialising in construction and engineering dispute resolution, based in the Edinburgh office of Shepherd and Wedderburn, and I'm joined by Nathaniel Buckingham, a solicitor in my team. Both Nathaniel and I regularly advise on construction contract issues and disputes across a range of projects and clients, so we therefore have a great deal of experience working in court where our arguments have to fall in line with ever-evolving judicial approaches to contracts. And this experience helps us to form the basis of our strategic advice and what we are going to share with you today. So I will now pass you over to Nathaniel, who will discuss this webinar's agenda.
Thanks, Iain. We will begin with a brief background on the freedom of contract principle, what it is and why it is important. We'll then go on to examine where and when the freedom of contract principle is restricted. Firstly, we will look at examples of statutory restrictions put in place by government legislation. We will refer to the Unfair Contract Terms Act 1977, and we'll examine the case of commercial management against Mitchell Design and Construct Limited as an example of how UCTA, the Unfair Commercial Terms Act, applies to construction contracts in practice. Secondly, we will look at penalty clauses and how construction contracts should be drafted to avoid leaving liquidated damages clauses vulnerable and potentially treated as penal and therefore unenforceable. We will then move on to examine the law surrounding termination for convenience clauses and good faith in construction contracts. We will use examples such as TSG Building Services against South Anglia Housing to illustrate the court's current approach to the concept of good faith in such circumstances. Lastly, we will examine implied terms and their impact on the freedom of contract principle. We will then provide a summary of the ways in which construction contracts can attempt to mitigate against these types of interferences with this freedom of contract where possible. The principle of freedom of contract, put simply, is the idea that parties can enter into contracts without any restrictions or interference from government or the courts. This concept is one strongly upheld by the law, as we have discussed in our previous webinars. For instance, the courts have stated clearly that when interpreting a contract, it is not their role to save parties from a bad bargain. Instead, the courts will give the words used their ordinary meaning, even where this leads to a very adverse result for one party. In this way, the courts have signalled their intent to avoid, where possible, reinterpreting contracts to give effect to what the court supposes to be the commercial common sense position. In this respect, the courts will interfere less with the contractual wording used than they perhaps did previously, and this was reiterated by the English courts earlier this month in the case of Leslie against Farrar Construction Limited. However, despite the force of this concept, there are two general justifications for restrictions on what parties can and cannot contract to. Whilst in light of what I have just mentioned this may seem unfair, it is precisely the concept of fairness that really provides for the first justification for these restrictions. Often parties entering a contract are not of equal bargaining power. An example in the construction industry might be a contract between a large, well-established contractor in the market and a smaller, relatively unknown subcontractor. Without restrictions, there is a possibility that the stronger party would have an advantage in any bargaining scenario. The second justification for restriction on contractual freedom follows on from this first one and is for reasons of public policy. So the government will not uphold contracts that are in contravention of the law or clauses that are considered to be penal in nature, and the government will make this public policy law where they deliberately and intentionally want to interfere, for example, to protect weaker market participants. I'll now pass back to Iain to discuss the statutory limitations set in place by the government in order to offer protection from unfair contract terms.
Thanks, Nathaniel. So one statute that undoubtedly limits contractual freedom is the Unfair Contract Terms Act 1977, or UCTA as I'll refer to it for short. The extent to which UCTA limits contractual freedom depends on whether it is being applied to a consumer contract or a commercial contract, because generally speaking, consumers are given more protection under the Act than businesses, and that's because businesses are expected to have a greater commercial awareness and therefore a better understanding of what they are contracting to and a better ability to protect themselves. However, there are parts of UCTA which specifically apply to commercial entities. For the purposes of this webinar, we will not go through all the relevant protections for consumers, and instead we'll concentrate on the Act's application to construction contracts. UCTA effectively limits parties' ability to avoid liability in their standard condition contracts. As standard conditions contracts are used in the construction industry, it's important to consider UCTA when drafting them. Whilst it's tempting for parties to look to limit their liability by using exemption or exclusion clauses, Sections 16 and 17 of UCTA curbs the effectiveness of these types of clauses in particular situations. Firstly, Section 16(1)(a) of UCTA provides that any term in a business contract which attempts to exclude or restrict liability for death or personal injury will be void. Secondly, Section 16(1)(b) provides that a term of a contract that purports to exclude or restrict liability for breach of duty arising in the course of any business shall have no effect if it was not fair and reasonable to incorporate that term in the contract. And then thirdly, Section 17 specifically bars clauses in standard term contracts which exclude or restrict liability for breach of contract or allow no performance or a different contractual performance to be made unless such a term was fair and reasonable. Now, UCTA doesn't define what is meant by either an exclusion or exemption clause, but generally they can be considered as clauses that attempt to either restrict or exclude liability, or make a liability or the enforcement of a liability subject to restrictive conditions, or restrict the rights and remedies of the wronged party, or lastly, restrict rules of evidence or procedure. For an exclusion or exemption clause to be reliable, it must be drafted carefully so it is free from any ambiguity. However, even there, it is then subject to the test of reasonableness under UCTA, and this is a relatively high bar to overcome. If the exclusion clause is either not clear or reasonable, then it will be held to be void and unenforceable. And the aim of this double level of protection is to ensure that the exclusion clause is fair and does not leave one party with no means of recovery for loss.
An example of UCTA being applied to a commercial construction contract was discussed in the case of Commercial Management Investments Limited against Mitchell Design and Construct Limited in 2016 this year. This case concerned the validity of the subcontractor's limitation of liability clause in its standard conditions. A defects claim was brought against both Mitchell and Regorco. Regorco asserted that the limitation of liability clause contained in its standard terms and conditions prevented any such claim from being brought unless it was notified within 28 days of the appearance of the defect or, at the latest, within a year of the completion of the works, and which the claimant's claim was not on either count. Justice Edward Stewart had to consider 2 points. Firstly, whether the incorporation of Regorco's terms, only to the extent not inconsistent with Mitchell's terms, was sufficient to mean that Mitchell had dealt on Regorco's written standard terms of business, so as to therefore bring Regorco's limitation clause within the scope of UCTA. And then secondly, the judge had to consider whether the limitation clause satisfied the test for reasonableness imposed by UCTA. On the first point, the judge concluded that it was not necessary for rigor clause terms to be incorporated in their entirety, and that instead, to the extent that the terms and conditions contained certain clauses that were non-negotiable, those clauses would indeed be considered standard terms and conditions, and so for that reason, even if other terms were negotiable, and therefore UCTA did apply to the subcontractor's exclusion clause. When considering the second point of reasonableness, Justice Edward Stewart considered whether the clause was fair in terms of Schedule 2 of UCTA, reflecting on the following points. Firstly, the strength of the parties' respective bargaining positions. Secondly, whether the customer would have had an opportunity to enter into a similar contract with another party without having to accept a disputed term, or whether the customer received an inducement to accept a term. Thirdly, whether the customer knew or ought to have known of the existence and extent of the term. Fourthly, where the term excludes or restricts liability if a condition is not complied with, whether it was reasonable at the time of contract to expect that compliance with the condition would be practicable. And lastly, whether the goods in question were made to the special order of the customer. Now, strictly speaking, Schedule 2 of UCTA does not apply in Scotland, so theoretically the test of reasonableness for the purposes of UCTA in Scotland is much more flexible. However, in practice, the considerations are broadly the same. Although the court in the Mitchell case acknowledged the importance of allowing commercial parties to decide how they allocate risk, it found that rigor clause limitation of liability clause was not reasonable for the purposes of UCTA. The factor that appeared most persuasive to the judge was that, bearing in mind the nature of the works and the likely time lag in the appearance of any defects, and the fact that Mitchell would have limited opportunities as a contractor rather than a user of the property to identify any issues in the works, and so therefore it was not reasonable to expect Mitchell to comply with the 28-day time limit in the rigor clause limitation clause. This case certainly serves as a warning that UCTA will apply to construction contract clauses, and as such any clauses that seek to exclude or restrict liability should comply with the Act's concept of reasonableness and fairness.
So what can be done to minimise or avoid UCTA interfering with your contract? Well, as always, the answer can be found in careful contract drafting. So it is important to, first, identify what losses may be suffered under the contract. Second, identify what types of loss should be excluded and consider whether these exclusions are fair and justifiable in terms of UCTA. And thirdly, where losses are attempted to be excluded, then the exclusion clause must use clear and ambiguous wording. Next, you should decide whether any claim for loss should be subject to notice provisions and whether the time frame of those notice provisions would be considered fair under UCTA. After that, you should decide whether a cap on any losses would be more likely to be considered fair under UCTA. And finally, one should bear in mind that certain liabilities simply cannot be excluded, usually liability for fraud, negligently caused death, or personal injury. If these are excluded, any such clause excluding those aspects is likely to be void. Another form of limitation on parties' autonomy to freely contract is through the prohibition of penalty clauses. The essence of a penalty clause is the exertion of undue pressure on a party to perform a contractual obligation with the threat of a fine or punishment for failure to perform. The courts will not enforce a penalty clause against the defaulting party because it considers it to be contrary to public policy. This is because the clause is not attempting to simply right a wrong, but instead to punish the defaulting party. Now that is contrary to the law of damages in the UK, which is designed to compensate for losses suffered, not to punish the wrongdoer, as happens, for example, in some states in the US. Therefore, where a clause is determined by the court to be a penalty clause, it becomes void and unenforceable. It can be difficult to distinguish between a valid liquidated damages clause and a penalty clause. It used to be the case that such clauses would be penal in nature if they did not reflect a genuine pre-estimate of loss, as set out in the 1914 case of Dunlop pneumatic tyre. However, in recent years, cases have introduced a new commercial justification element for the test, which has added some confusion to this area. Useful guidance on how to determine whether a liquidated damages clause or similar is a penalty clause or not was provided in the Supreme Court cases of Cavendish Square against L. Macdacey and Parking Eye against Beavis in 2015. In these cases, the Supreme Court held that if a simple liquidated damages clause in a construction contract includes a sum that a defaulting party can show is out of all proportion to the other party's legitimate interest, the defaulting party may seek to challenge the clause, and if successful, that clause would be unenforceable. So under this new test, in order for that challenge to be successful, it must be demonstrated that, firstly, there is no commercial justification for inclusion of the liquidated damages clause. Secondly, the clause is extravagant or oppressive. Thirdly, its primary purpose is to deter breach rather than to compensate for loss. And fourthly, and this consideration is only whether it's relevant, fourthly, the provision, whether or not the provision was negotiated on a level playing field. So the law has more recently moved on from a simple dichotomy between liquidated damages clauses on the one hand and penalty clauses on the other, depending on whether or not each are based on a genuine pre-estimate of loss. It is now no longer sufficient to show that the clause is not a genuine pre-estimate of loss, and there are now other considerations for a successful challenge to be, for a challenge to these clauses to be successful. So although the scope for challenging liquidated damages clauses is now reduced, particularly since those two cases in 2015, there still remains an area where the courts may, albeit in extreme cases now, but may still intervene, and that's still a relevant issue for the construction industry due to the widespread use of such clauses.
Generally speaking, the courts are now reluctant to intervene in commercial contracts and declare liquidated damages provision a penalty, as Iain's just mentioned. And this is illustrated in Phillips against the Attorney General of Hong Kong from 1993, where the following statement was affirmed by the Privy Council. And the statement is, "It is now evident that the power to strike down a penalty clause is a blatant interference with freedom of contract and is designed for the sole purpose of providing relief against oppression for the party having to pay the stipulated sum. It has no place where there is no oppression." That being said, where it is possible to protect your contract from any attempt of interference, it is best to do so, rather than rely on the courts to do so. The simple way of doing this is to firstly demonstrate that the clause is not penal by basing it on a genuine pre-estimate of loss. Be careful to calculate your potential loss accurately, in advance, and preferably keep good records of this. Doing so will certainly help to later demonstrate that it is neither extravagant nor oppressive. Where an accurate pre-estimation is not feasible to account for, then the clause must be carefully drafted to reflect a commercial justification for the sum. While it will now be an exceptional case, the courts will still interfere and strike down such clauses if they are excessive. Another potential limitation on the freedom of contract is the principle of good faith. The test for good faith is generally accepted as whether or not the behaviour and actions of a party could be considered as commercially unacceptable by reasonable and honest parties. And whilst in many civil law jurisdictions this principle is strictly adhered to, in the UK, both north and south of the border, there is no general duty of good faith applied to contracts. But an example of where the concept of good faith may begin to interfere with construction contracts is where there is a unilateral termination of contract for convenience clause, or a termination for convenience clause. The principle of good faith is sometimes argued when these clauses are applied in cases where termination for convenience was for the purpose of appointing an alternative contractor. However, even where this is the case, the courts have been reluctant to base a decision solely on good faith. An example of this can be seen in Hadley Design Associates against the Lord Mayor and citizens of the City of Westminster from 2003, where the owner intended to use another contractor to complete the works on termination. Hadley Design argued that the termination was therefore in bad faith and that it was an implied term of the contract that any termination must be carried out in good faith. Nevertheless, Judge Richard Seymour QC found there was no necessity for such implication in the contract, and therefore that a duty to act in good faith would not be implied. Despite this clear statement, in more recent years, English case law has seen a growing willingness of the courts to imply a duty of good faith in certain circumstances. In Yam Seng against International Trade Cooperation in 2013, for example, it was held that a duty of good faith could be implied into an English law contract where it was right to do so, based on the presumed intention of the parties and the relational nature of the contract itself. Soon after, in Mid-Essex Hospital Services against Compass Group in 2013 again, the court found that the exercise of a power to terminate for convenience is surely a simple decision whether or not to exercise an absolute contractual right, and therefore the issue of good faith does not arise. However, the court also acknowledged in this case that certain categories of contract could contain an implied duty of good faith, particularly where a party makes an assessment or chooses from a range of options and therefore has to take into account the interests of both parties. With that said, the English courts have signalled an unwillingness to imply good faith more generally in contracts, and the decision of the Court of Appeal in MSC Mediterranean Shipping against Cottonex Ansalt in 2016 clarifies that the position under English law is that there is no general duty to act in good faith. Lord Justice Moorbeck stated, "The recognition of a general duty of good faith would be a significant step in the development of our law of contract, with potentially far-reaching consequences, and I do not think it is necessary or desirable to resort to it in order to decide the outcome of the present case." There has not been a similar development of case law in Scotland, and whilst a broad principle of good faith and fair dealing was recognised in Smith against Bank of Scotland in 1997, the case has been very narrowly treated by the Scottish courts since it was first decided. Therefore, generally, good faith will not be implied by the courts into contracts, and specifically case law suggests that the courts will not imply good faith to the termination for convenience provisions of a contract. However, please note that this is a developing area of the law.
The court's reluctance to intervene in contracts by implying a general good faith obligation is clear, but there are construction contracts that have express good faith provisions. It might be common sense to think that this good faith provision would apply to termination for convenience clauses in the same contract. However, in TSG Building Services against South Anglia Housing in 2013, Mr. Justice Aikenhead held that a partnering good faith clause in a contract did not impinge upon either party's right under that contract to terminate the contract at will, even where the purpose of doing so was to give the works to another contractor. A more applicable example of an express provision for good faith having limited influence in practice can be seen in NEC 3 Option B, the 2005 edition, where Clause 10.1 requires the employer, the contractor, the project manager and the supervisor to act as stated in this contract and in a spirit of mutual trust and cooperation. While this clause may seem to provide an element of good faith in construction contracts which are subject to those conditions, in reality it has limited effect. However, this is an area of law to watch. It's likely to develop, influenced by European contract law traditions of good faith in all commercial dealings. It is often resorted to in arguments before the courts now, and is likely to be applied in certain limited circumstances in future. So whilst a general duty of good faith is still unlikely to be implied, it is better to have contracts that will leave this issue in no doubt. And again, the key to success in doing that will be clear and unambiguous drafting, taking into account the following. First of all, it's important that there is clarity in the scope of the termination for convenience provision, if there is one. Is it or is it not permissible to terminate in order to instruct a new contractor? That should preferably be expressed in the clause. So, for example, some standard form construction contracts have taken this requirement for clarity into consideration, but to the opposite effect. So the FIDIC 1999 Red Book, Contract Clause 15.5, for example, provides a termination for convenience clause, but it also provides that the principal may not terminate the contract in order to execute the works himself or to arrange for those works to be completed by another contract. Secondly, where there is express reference to good faith, be aware that the courts will consider and construe such provisions narrowly. Therefore, if it's intended that the good faith provision should have teeth and, for example, should apply to termination for convenience provisions, then that should be expressly stated. Finally, similarly, if a good faith provision is not intended to apply to termination clauses, but is intended to apply to other clauses, again, that should be expressly stated, so as to avoid any doubt as to what both parties are contracting to. I'll now hand back to Nathaniel, who will discuss the implications of implied terms on freedom of contract.
Implied terms are terms that have not been expressly agreed by the parties, but are implied into the contract by the court. The power of the courts to imply terms into a contract is in theory limited, but it happens fairly regularly that the court will agree to imply terms into a contract through the operation of common law principles. Some examples of terms that are applied into construction contracts include the Housing Grants Construction and Regeneration Act 1996, as it's been amended, implies into a construction contract the payment provisions from the Scheme for Construction Contracts regulations, unless the contract already contains an adequate mechanism for determining what payments become due and when. Likewise, the right to refer a dispute arising under the contract to adjudication must also be adequately provided for. If not, then the whole clause falls out of the construction contract and the scheme will replace the clause in its entirety. A second example is the Late Payment of Commercial Debts Act 1998. This act gives businesses the statutory right to claim interest on late payments for goods and services from other businesses, as well as a fixed sum and reasonable costs for recovery of the debt. The current rate is 8% above the prevailing base rate. And a third example, or thirdly, other general terms are sometimes implied in order to fill a gap in a contract. For example, that performance should be started within a reasonable time, or that a person carrying out the work impliedly undertakes to exercise the ordinary standard of care and workmanship of a practitioner of that trade, even if those aspects aren't explicitly stated in the contract. The traditional tests that have been most commonly used when determining whether a term should be implied into a contract are, firstly, the business efficacy test. The proposed term will be implied if it is necessary to give business efficacy to the contract. The second test is the officious bystander test. The proposed term will be implied if it is so obvious that an interfering bystander would conclude the proposed term is so obvious that it goes without saying. However, there have been further developments through case law. The current test, put simply, is that a term can only be implied into a contract if it complies with the following. Firstly, if it is reasonable and equitable. Secondly, if it gives business efficacy to the contract, so that no term will be implied if the contract is effective without it. The third test is if it is so obvious that it goes without saying, and that's the bystander test we just talked about. Fourthly, it must be capable of clear expression. And fifthly, and finally, if it does not contradict any express term of the contract made between the parties. This test, and these parts of the test, is really a relatively high bar to overcome, and again illustrates the court's recent hesitancy to imply terms into a contract that has been negotiated and agreed between two parties. This test was reiterated in the recent case of Marks & Spencer's plc against BNP Security Services Trust in 2015. Whilst Lord Neuberger added his own comments to this test, he reiterated that it was in no way meant to be read as a relaxation of the high bar that implied terms must overcome. With that said, there are tests that do overcome this high bar, as our examples we discussed illustrate.
So finally, ultimately, there are limitations on how contracts can mitigate interference by implied terms, but the sorts of steps that can be taken to minimise the impact of this interference are, firstly, be aware of the sorts of terms that might be implied into the contract. Secondly, avoid express terms which are not compliant or not likely to be compliant with those likely implied terms. And thirdly, identify potential implied terms that you may wish to exclude from the contract and assess whether it is possible to contract out of them. And as always, if you're attempting to do that, then you must ensure that the clauses use very clear and unambiguous language to make it clear that the exclusion is intended and what the effect of that exclusion is intended to be. So, what can we take away from today? Well, this webinar has highlighted that despite freedom of contract being held as a fundamental doctrine of contract law in the UK, in practice this is not always the case. There are a wide variety of limitations on the ability to contract in the interest of fairness and public policy, some of which we've touched on today. I think what is important to take away from today is to be aware of those interferences and to try to provide for them when you're drafting your contracts. The courts and legislature are generally reluctant to interfere, but the truth of the matter is that they do. And these interferences are generally limited, but they do impact on construction contracts in practice and reality. So where measures can be taken to mitigate against those interferences, then extra care should be devoted to doing so. So in conclusion, please be aware of the potential different types of interferences. Assess what interferences or which of those interferences may impact on your construction contract. Thirdly, make sure you carefully draft your contract so as to avoid those interferences where possible. And fourthly, make sure that your contract is compliant with legislation and common law rules to avoid entering into costly disputes. Okay, so that closes our webinar for today. If anyone has any questions, please feel free to type those up in the dialogue box. That's us certainly come to the end of our formal presentation. So it doesn't look like anyone has any particular questions, and I'm aware of the time. We've come to the end of our allotted time. So I think all I'll do at this stage then is to bring this webinar to a close, and thank you very much to you all for joining us. I hope it's been interesting and that you've enjoyed the series. And as I said, all of our 3 webinars are recorded on our Vimeo site, so please don't hesitate to download those and listen to them, pass them on to colleagues as you wish. So thank you very much for joining us.